Hello, and thank you for joining us on today's Ask Andrew show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal of Feldstein Family Law Group. Both myself and our entire firm practice exclusively family law in the province of Ontario, with offices in Markham, Vaughan, Mississauga, and Oakville. And today we're joined by a special guest, Tami Moscoe, to discuss the topic of unbundled legal services. Tami is a senior family law counsel at the Superior Court of Justice, providing advice to Chief Justice Morowitz and Senior Family Justice Stevenson on any and all issues relating to family law, family court processes, and unified family court. Can't believe I made that mistake after all these years of a unified court. This includes developing internal and external resources for the Superior Court of Justice to assist with resolution of family cases, including a new guide to process for family litigants. Tami, welcome to the show.
Hi, Andrew. Thanks for having me.
Now, you joined the public service in 2006, and you also practiced family law for 8 years. And you were at a large family law firm before that also had other areas of practice. So you actually had very unique or very helpful experience when you started down this road. I guess it's almost 13 years now that you've been working in the role you're at.
Yeah, I've actually had 2 roles in government, but all in family law. And my family lawyer experience and my family mediation experience have come in very handy in various issues along the way.
So today's show is about unbundled legal services. And for viewers who may not be familiar with the concept of unbundled legal services, can you give a brief explanation of what it is?
Sure. And I mean, you're the one who provides these services, so you can jump in at any point. Unbundled is sometimes referred to as limited scope, and it's where the client and the lawyer agree what the lawyer will do. So unlike a traditional retainer where the lawyer takes on responsibility, with unbundled, the default is that the client is responsible, subject to what's agreed to that the lawyer will take on. So for instance, you can have an agreement with a lawyer that they will go and represent you or attend one attendance at court for you, or you can hire a lawyer to to give you advice at a certain time, like as a part of a mediation. And there's all sorts of different ways to slice and dice it, but it's basically a DIY way of retaining legal services where the client decides what the scope and involvement of the lawyer is.
Okay, and do most family law lawyers provide that kind of work or service to their clients?
I would say most. I think the landscape has really changed over the last 3 or 4 years. I think most family lawyers do it to some extent. But in the last couple of years, a larger number of lawyers are doing it more openly, and they're marketing that they're doing it. So, Andrew, you're familiar with the Family Law Limited Scope Services project that I have been involved in, and we have over 200 family lawyers involved there and over 50 communities in Ontario. So it's certainly more visible now that lawyers are working in this way.
Well, I remember at our firm, we probably started on this path over 10 years ago. And when we started on it, I know when I spoke to other lawyers, there was a great deal of reluctance by many lawyers to want to provide limited scope retainers. And I used to say to them, here's the practical reality. Some people have limited resources, and they may have decided that they have $10,000 and that's their entire budget. And when that's their entire budget, they want to utilize it to their very best potential. And I've always used the example of when I go to buy a car, we all want to have the safest and best car. And to me, that means if I can have a Mercedes or BMW that has 5-star rating on accidents and a fast engine, I'm probably thrilled. But if I can't afford that, I have to make compromises and get something that may not be as exciting. And I view limited scope retainer like that. I say to every client, a comprehensive retainer is the best choice. It's the best option. But if you can't afford that, then let's talk about what we can do to help you in a limited scope retainer. And I don't know if your experience is you're seeing more lawyers take on that kind of viewpoint.
Yeah, I mean, I think the reality is that because of finances, many people aren't willing to give away that carte blanche, the way we were trained to lawyer. So you have people, a lot of people who have the ability to pay for some legal services, but need to maintain control or want to maintain control over the amount of money that they put into the case or the mediation or the negotiation. So it's almost like people doing their own bathrooms. Some people feel that they can do it and they'll start to do it and then they'll realize they're in over their head and then they'll hire a contractor. So lawyers can be involved at all stages. I always used to say to people, go get advice early on because you can make a lot of mistakes if you don't get advice. But there's different ways to slice it and dice it. And certainly it's a more affordable way for the client to maintain control over the amount of money that they're spending.
Well, thank you as I see you struggle through this.
I have a cough. It's, yeah.
I get it. We've all been there. I certainly...
Not COVID. I don't have COVID. It's all good.
Okay. Well, I certainly get it from the perspective of people who say they don't have the resources, but what you did hit on the nose is get the advice early, because sometimes a client will come into me and they get served with an application and they've done the answer on their own. And the answer is absolutely horrid because they've said all sorts of things that are really foolish and really bad. May have been all sorts of negative commentary about their former judges. And when that happens, we're then put in a position of having to try and clean up that mess. And when the mess is that horrible, there's only so much you can do to clean it up. And I've had cases where I remember I had one client come in and his answer was just full of scathing commentary about how his wife of 25 years was a lazy, good-for-nothing piece of garbage because she didn't want to go back to work. And therefore, the kids shouldn't be with her. And I see Tami smiling because when you put that kind of material in front of a judge, you can just see the spousal support is going to be going up, time is going to be going down, and your whole dance is to try and get the client to say, my mea culpa, I was full of anger at that point, but it's always out there and it's always a problem. So what Tami is saying about getting advice early is, I think, really important. And the other thing that I think is really important for those viewers thinking of limited scope retainers is being strategic if you have a limited budget. I remember I once had a client who was incredibly strategic with how he used me on a limited scope retainer. The other side brought a motion that was really important in that case, and he hired me to draft his affidavit material for the motion and to give him advice on how to argue the motion. So we did that, did it on a very reasonable price. He went in, argued the motion, beat a lawyer, got costs, didn't hear from him for 2 years. And then he had a settlement conference coming up 2 weeks later, and he came into my office to try and help me to help him settle his case. I spent a day with him in my boardroom, put together his arguments for the brief and did his offer to settle, sent it over to the other side. And then in another half a day, we did some negotiations and resolved the case. And to me, that's
I think also, like as a client, I think you need to think about how comfortable you are running the show on a day-to-day basis, right? So some people need to pay lawyers because they don't want the responsibility and they'll feel like they're in over their head. But others are fairly comfortable or comfortable enough doing so and really just need help at strategic points. I just think it's really important, like for sure before you go to a mediation, for sure before you go to a court attendance, like the system works when people are knowledgeable about their rights and obligations. And when they're not is when people really, struggle to make their way through. So I certainly think that you can use Unbundled and put yourself in a better place to get through the case in a more streamlined way.
Well, I see we have a question from one of our viewers. They wanted to know, what is the cost of unbundled services? And that really is an impossible price-wise. How do unbundled fees compare to traditional divorce fees? They're going to be less, no doubt, because you're doing less work for the client. But the real problem is at the end of the day is you're taking a risk, because every time you write an email or you write a letter to the other side, or you do an affidavit to the other side, or a court document to the other side, you may not appreciate the nuances of what you're saying or what you're doing. and you may completely and utterly shoot yourself in the foot in doing it because you can't appreciate it.
And then the lawyer may have to fix it afterwards, right?
And the fixing it is so much worse. I had one case where this person hired a paralegal who wasn't supposed to be practicing family law, but they were. And they gave advice to my client to not show up at a trial because it was the second day of his work, and send in somebody else to say he couldn't go to the trial because he was working that day. 1 hour later, the judge had rendered a final order.
I was going to say, how'd that go for them?
The price that gentleman had to pay for me to go to the Court of Appeal, to bring a motion to set aside, and then resolve the case afterwards was astronomical. And it could have all been avoided had he hired a lawyer. Had he had a lawyer before the trial, the case would have probably settled because the positions were not unreasonable, and the case settled at a similar position of what was being discussed before the trial. So
I think
again,
the big issue is that clients maintain control over the fees. So it will likely be cheaper, but it depends on how much the client will handle and how much help they need or want from the lawyer. So is it bargain basement lawyering? Likely not, because you get what you pay for. But you can decide the extent to which you want the lawyer to take responsibility for what needs to get done, which, as Andrew has said, can often make things get settled earlier as well. But it's not regulated, so lawyers can charge their fees. The client just maintains control over the scope of the work that's being done.
and I think what you said there was really important, which is a lawyer can get the case settled quicker because we also understand what is a realistic outcome. And when a client walks into my office, I can gauge what the realistic outcome is in a lot of cases early on. And I can put the client on the right path because I'm sure you remember in practice how many times you do an initial consultation and the client's expectations at that initial consultation are outlandish.
Yeah.
And a big part of it is bringing them to realize what reality may look like. And it's much better to realize that at the beginning than at the end when you've spent a fortune. I see that there's another question that came in, which is, would unbundled services ever be used for secondary counsel with a primary divorce attorney?
So I've never seen it used that way. I guess the question is, what's the problem with the primary attorney? What I did in private practice a lot is that we would be consulted if someone wasn't sure that their lawyer was handling the file properly. So lawyers are often consulted to see where the client kind of loses confidence or isn't sure. So a second opinion. So we certainly, lots of lawyers do that, and will usually tell you to stay with the lawyer because they're doing a decent job. But I don't know why you would want to incur the cost of having a second lawyer involved unless your lawyer's not doing a good job, and then you may want to think about changing lawyers.
The only other time I really see that, and there's quite often there are two lawyers, because there are family members that get involved in the file. The most common one is when one family member is brought into the file because there's an argument, was it a loan or a gift, and the other family member is trying to collect on the loan. So the lawyer, even though it may be, it's a mother and child or father and child, and they're usually, you'd view their interests as aligned, they each need to have their own lawyer. So maybe that's what this person is also talking about. Could be a second opinion, but it could be they have a second lawyer for that. And maybe that second lawyer is just being used on a limited scope retainer. I could see that perhaps making some sense of the situation.
Yeah. Sorry, that does make sense.
Now, our next question is, and I think we've sort of touched on this, but what would you say is the biggest advantage of an unbundled legal service?
Well, I think maintaining control over the cost and also the trajectory, right? So some people want to be in the driver's seat and they want to know everything that's going on and they want to be the one who's calling all the shots. So for those people, unbundled is great because then you're just getting the help when you need it or when you want it. But affordability is a big issue. And just like we said before, it's not necessarily or it's likely not a cheaper hourly rate, but it's just you're limiting the amount of work that's done based on what you want.
Well, the other thing, and I know you've been centrally involved in this as a key figure, is because of COVID, the court has actually moved, I would say, into the 21st century finally. It's interesting because I was telling one of my articling students yesterday about the way the process was before COVID. And she couldn't believe it when I explained to her that everything had to be filed in court in person. So you'd hire a process server to go do it. She couldn't believe that every court appearance had to be in person. And, we as lawyers, we take it for granted that on the day of a motion, you show up and there can be 10 matters on the judge's docket that day. And you get there for 9:30 or 10 o'clock, depending on the court. And you may not leave till 6 p.m. that night. And that she goes, what did the clients do for that? I said, well, they paid you to sit there and wait for your turn. And it's interesting because she was shocked by that. But now, thanks to COVID, the whole system has changed dramatically. And I think it's saving clients a lot of money. And I think access to justice is far improved because now when I had that court appearance that would have been till 7 o'clock p.m., I'm doing much better now in terms of how little time I'm spending on a matter in comparison to before, because I'm not sitting around waiting for hours. And if a judge tells me I need an extra hour, I log out of Zoom, I go back to do work and log back in at the predetermined time.
Yeah, there's lots of upside. I before getting too excited about that, I would say that we're still learning because, for instance, when lawyers don't talk, which some lawyers do before the event, right? That time where you were sitting waiting in the hallway at the courthouse, you were usually settling cases, right? So we're still learning about what the impact of virtual attendance is, it's still, this is brand new, and we changed things really, really quickly because we had to. And the affordability is huge. You're not wasting time in the same way, but there are some downsides that we're learning about too.
Well, I know you can't say what the policy will be post-COVID. I can tell you as a practitioner, though, it's been wonderful for events like case conferences, short motions, where the clients are really getting much better value, because if I have a short motion, I mean, even the one I had last week that was on an open motions list that I had to wait my turn, I wasn't waiting for hours sitting around court. I do understand what you're saying. To me, for whatever it's worth, having the settlement conference days in person probably makes a lot of sense to address what you just said. But from a client's perspective, I think it's certainly wonderful in terms of the cost, because I look at what my dockets are on the day of a court appearance and they're far less than what they used to be. And if I'm the client,
our electronic filing, so you're not sending someone in person. Like, there have been lots of efficiencies that we've been able to bring into place over the last 10 crazy months. But we're still learning about what works best. And especially for self-represented litigants, we've lost some of the supports that we had in in-person court. There's some drawbacks there too, but I don't need to get into that too much today.
I wanted to say kudos, and I think that that's something that allows the self-represented litigant who wants unbundled legal services to actually get further with their limited resources, because we can take it further. I see there's a question here: are video consultations an example of unbundled services? Do you want to answer?
So, 10 months ago, lawyers were not giving virtual services like they were 9 months ago. Everyone has kind of pivoted to doing work on a video basis. It's great because it means lawyers are accessible all over the province. That's particularly good when clients speak certain languages, for instance, that may not be available locally. Consultations are a way to get unbundled. Legal coaching is another really more new way of getting unbundling. So legal coaching is where the lawyer is in the background and never does an attendance or takes on responsibility, but they're there to give you advice and information. So you can consult with a lawyer, you can ask procedural questions, you can ask substantive questions, you could get advice on a potential settlement or resolution. So sure, consultations at any stage in the process. would certainly be part, sorry, of what we're talking about.
Well, in fact, I know I've done that in court matters before. And I've also done it in mediations when the parties have privately hired their own mediator and they're going without counsel. And I say to clients all the time, it's really worth it, because the biggest question I always hear from, or I tell my clients when they go into the mediation, is if you have realistic expectations, it's critical, because when you find out the deal that's on the table is reasonable, you're probably going to make a deal and avoid a lot of conflict. Because I've had people come to me and they come in and they say, I can't believe what my spouse is asking for. It's completely and utterly outrageous. And now the deal that was on the table at mediation is completely gone and off the table. And what they're hearing is 10 times worse. And had they come to me when they're in the mediation, I would have told them, that's a good deal. Go do it. Get your piece.
Well, so one of the best practices that we have for the Family Law Limited Scope Service Project is if a lawyer has helped you prepare for an event, to be available during the event for a quick consultation. So you prepare for your settlement conference or mediation, the lawyer gives you a roadmap about the likely scope of resolution, and then the judge or the mediator says, well, what about this, or how about that? And so, Andrew, I want them to be able to call you, not that you have to be on the hook for the 3 hours of the mediation, but for a 20-minute phone call. So if they can call you and say, you know what, Justice X is suggesting this, what do you think? And then you can give them advice because you already know what the issues are, and then maybe they can settle it right there and then. So what we really want is we want the unbundled services to help facilitate resolution as opposed to becoming an obstacle. Because as you know, court dates are few and limited.
So I was going to say, we have another question coming in. Are unbundled services fixed or firm? And I'll let you answer that, Tami.
There's nothing fixed about them. So think about it as a pie. You cut in up pieces, and it's about what you want to have the lawyer do.
That's helpful. And I think it's really important to realize what some clients can do if they want your help with something, i.e. take coaching as an example. Some clients will say, Andrew, can I buy 2 hours of your time? And let's set up a phone call, and maybe 2 or 3 phone calls or Zoom consults. And it's like there's a meter there that's running until it's used up. And, and sometimes the best advice we give is not to do anything. I mean, I always think about the motions to change. So it's when someone is unhappy, typically with what they're paying in support. And we see this all the time. And I'm sure Tami saw it when she was a practitioner as well, where the payor comes in with their new spouse and they're really upset, or they aren't that upset, but you can see the spouse is really upset with what's being paid to the other household. And you tell them it's a good deal. Don't do anything. And you can see the relaxation in the potential client because they're happy, and you see now the other spouse has been satisfied. So why I'm saying that is somebody can come in for that kind of advice. And the irony is that 1 hour advice of doing nothing can be the most valuable advice they would ever get, because assessing the case before you start down the road can be critical, because you can end up wasting a lot of money and end up paying more.
Oh, for sure. I mean, I've seen cases where people go into a variation and end up doing worse because the guidelines have been updated or a child has become disentitled to support. So again, I think getting advice at those timely junctures can be incredibly valuable. And like you said, you can do it in a kind of contained way. So you spend a couple hours, you see the lawyer, and then you decide what you want to do. And you're informed and you're making more informed decisions.
I believe it's really important to measure the goalposts before you start down a pathway. And sometimes you can look at it, you can say to a client, well, you know what, maybe I'll shave $200-300 a month off your support, but it may go up by $2,000-3,000 at the end of the day. Do you really want to go down this path right now? And a lot of smart clients will say, you know what, Andrew, thank you so much. I'm happy not to spend the money on you, because there's no real upside. And it's not just the financial upside. It's the stress. It's the additional conflict. Because for anybody who's been to court, ask yourself the question of what you felt like the night before court. and how stressed you were and how stressed you were the week leading up to court. If you're going to put yourself through that, make sure there's a worthwhile upside for it. Otherwise, don't bother.
Well, also, family law is complicated, and there is still lots of discretion in the law. So sometimes sticking with what you know is better than taking your chances. But again, once you get the legal advice, you'll be in a better position to make that decision.
Well, I think that's important. And the other thing, when you say family law has a lot of discretion, is I'll get clients who come in, and my favorite is when they bought the rule book or they bring copies of the statute in because they've read it, and they quote a section in a statute, and their view of it is that's what's going to happen because, they read it in the statute. And I quickly will point out to them that they're misreading one really key word, and the key word is may. And I tell them that means it's discretionary. And when you see that word may, you may want to ask me, in my 27 years of practice, how many times have I seen a judge exercise their discretion that way? And they get all flustered by that.
Or how would they exercise their discretion, right?
Pardon me?
Or how would they likely exercise their discretion?
Yes, and frequently the client they get very upset and frustrated because they think they have a brilliant argument. My point is, don't expect this to happen this way because it really doesn't happen that way. There needs to be some exceptional circumstances in play for it to go your way of what you want, and they just aren't here. And that's one of the problems when, two of the biggest mistakes people make when they represent themselves, and I would even say that when I went through my own divorce, I did not represent myself. I had outside counsel represent myself because I may have an understanding of the law, but I lack objectivity when it becomes my own matter. So one of the things you're buying is objectivity. And the other thing you're buying is the experience of your lawyer for the nuances of a case based on the way the case needs to be presented and how a judge is going to interpret it. And the presentation can be very important. And the other part is understanding that overall feeling from years and years of practice of where courts typically go with these kind of cases. And
we know most of these cases settle at some point. So really, a small portion, I don't know, some say it's 3%, some say it's 5%, end up going to trial. So the lawyer is not only just presenting your case, but they're giving you advice about what's a good settlement in the circumstances. What steps should you take to move the case forward? So there's all sorts of, because clients don't want a process, they want a result. They want to be done and they want to get a reasonable outcome based on their rights and responsibilities, right? So that's the role of the lawyer.
And that's one of the things we can give to clients and bring them that air of reality from their own research that they do. And that's why the research that they do has to be done in conjunction with talking to a lawyer to understand whether it's realistic or unrealistic in terms of their expectations. I would ask you, because we're almost out of time now, so I thought I'd ask one last question. If you were, maybe a loaded question, but if you were in the situation of somebody coming to you and saying, I want an unbundled service, what would be the one critical thing that I should know before I go down that path? What would that be?
Well, I actually highly recommend that you look at the resources that we put together on the Family Law Limited Scope Services page. And Andrew, maybe we can add that, the website at some point. We have a whole section about information for clients, and it helps the clients to get a general understanding of the process and the issues that you face. And I think that, Andrew, the goalpost language that you use, or I use road mapping, anytime you use a lawyer, I think on a full retainer or an unbundled, the question is, where am I? Where am I hoping to get to? And what are the steps that I need to take to get me there?
And that's an absolutely great point that you have, because I think as lawyers, one of our greatest failings is communicating to clients just that type of commentary. Clients want to know where they're going, what the strategy is to get there. And I think as lawyers in general, we have to do a better job of communicating that to our clients, because I find when I do that with my clients, I can see the calm come over them when they get the feeling that there's a plan and there's a way that we're trying to get them to the end.
Yeah, now family cases do evolve, and so it's a challenge that family lawyers face. So sometimes information comes up or claims change. So, it's not always some certain A to B to C, but you want to have a plan. And whether you're executing the plan on your own or with the help of a lawyer or they're carrying the ball, I think that's what we need to focus a little more on. How do I get to the end of this process? What steps do I need to take?
Okay, well, we're out of time now, Tami, and I wanted to thank you for being on the show. It was a pleasure having you tonight. The next Ask Andrew show is on March 17th at 8 p.m. If you have any requests or ideas for shows, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.